next case to come before the court is Abdelqader Holdings versus the Akron Board of Zoning Appeals. Each party will have 15 minutes to present its arguments. You may reserve up to 5 minutes for rebuttal. Just let me know before you get started. I'll be doing my best to keep track of the clock. There's also a clock up on the wall that works 90% of the time. So far, we've had good luck today. Keep in mind, though, that 15 minutes is inclusive of your rebuttal time. We have read your briefs, and we are ready to proceed when you are.
Thank you, Your Honors. May it please the Court, my name is Thomas Marino, and I'm the attorney for Abdelqader Holdings, LLC. And at this time, I reserve 5 minutes for rebuttal.
Okay, thank you.
In this administrative appeal, the trial court affirmed the BZA's decision to enforce a U3 retail zoning prohibition on tire sales to a portion of a single piece of property that is split over. It was argued before the BZA and the trial court that that enforcement is arbitrary, unreasonable, and ambiguous, as well as unconstitutional as applied, because it effectively limits and rezones the less restrictive portion of the property. The trial court failed to analyze that issue in that context. That it affected the less restrictive portion. And then in deciding constitutionality, the trial court further struck any evidence beyond what was before the BZA at the hearing. And those actions constituted abuse of discretion and reversible error. Without going into much of the facts, but this being an as-applied challenge, the property is less than 13,000 square feet. The zoning map, as it currently is, divides this property nearly up the middle. The eastern portion is zoned U3 retail, and the western portion is zoned U4 commercial. Tire sales are permitted in commercial zone property. They are not permitted in retail zone property. It has been asserted since before the BZA, from the BZA and on, that Abdelqader is entitled to use the least restrictive use of the property where enforcing the more restrictive use directly affects that portion. The structure situated on the parcel is also split by the zoning line. It's not split nearly up the middle, but a third of it is. And so, in essence, my client is being expected to use half the property because, as the trial court found, sales were only occurring on the eastern portion. Now, while this court can only review questions of law on these types of appeals, the trial court still must analyze the evidence before it. Otherwise, it's an abuse of discretion, and this district has said as much in South Park Limited versus Council of City of Avon, 2006, Ohio 2846. Here, the opinion that concerns the ambiguity that has been asserted was one paragraph, and there was no analysis as to its effect on the parcel as a whole. In the record, the evidence reflects that this parcel on the county fiscal website is zoned commercial. There were no opponents that appeared at the BZA hearing. The ward councilman who received the complaint was not present at the hearing. And the initial complaint was initiated with the zoning department through a competitive tire salesman down the street. In fact, the zoning manager of the city could only speak to an unnamed neighbor with unspecified concerns about use of the property. There were no complaints about increased traffic, no complaints about increased sound or noise, no issues with respect to smell or any sort of reasonable relationship to the way the zoning scheme is currently set up. And so the court's silence on those aspects revealed that it abused its discretion in the sense that it didn't even consider this very issue. The second tentacle to this, and it's related to all of those foregoing facts, is the as-applied constitutional piece. The case law states that an as-applied constitutional challenge, even if a part of an administrative appeal, is to be treated as an original action. And that makes sense because the administrative agency doesn't have the authority to make any ruling with respect to that. But I implore this court to consider what is the benefit of an original action when the trial court treats that issue as though it's being constrained within Revised Code 250604. And that's exactly what it did when it struck 10 exhibits from the appellate brief, is it cited that particular statute and said that it didn't have authority, that no motion was filed.
Were any of those documents before the BZA?
Say that again,
Were any
right?
of those documents before the BZA?
Those specific 10 documents were not before the BZA. And what I'm trying to argue is that that aspect for a trial court to consider an as-applied constitutional challenge should and must hear more evidence than that which is before the BZA. Sure, there needs to be some argumentation at the administrative agency level to be able to develop the factual record. But when a trial court acting, which has to have an original action in an as-applied constitutional challenge, if not have a hearing, certainly consider evidence even beyond what was before the BZA. And that makes sense because if a party challenging constitutionality has to do so beyond fair debate, it's nearly an impossible burden for a party to be able to achieve that if all they're able to do is produce the evidence that was before the administrative agency in front of the trial court. I would cite this court to numerous cases that are in the brief with regards to treating these particular causes as original actions. Ambrose versus Village of Galena, 2015, Ohio 3157. Snee versus Jackson Township Board of Zoning Appeals, 2003, Ohio 5319. And I know that there are others within the brief. This property was a vacant, unused car wash until tire sales began. It was essentially valueless until Abdelqader made a business use out of it. The United States Supreme Court has held that absent of showing that the ordinance bears a substantial relation, it uses the term substantial relation to a proper public purpose, it's unconstitutional as applied. The Ohio Supreme Court holds that in an appeal which challenges the constitutionality of a zoning ordinance as applied, the issue for determination is whether the ordinance has any reasonable relationship. And that's Mobile Oil Corporation versus City of Rocky River. So when the city, in its briefs, raises questions as to, well, what do all these facts mean? What do they all matter? Well, they matter because while they're certainly entitled to a legitimate exercise of police power, they're certainly entitled to create these zoning schemes, there has to be a reasonable relationship of that power, of that legislation, to the property. And there was nothing in the record beyond the fact that the property to the west was being used as retail, even though it was zoned also commercial. The properties to the south of the parcel were also zoned commercial. To the east, it was a convenience store. The properties to the north were being used and are zoned residential, but so are the properties to the north of all the other commercial properties. Now, that would be in the record for the trial court, but it struck those maps. Some of those 10 exhibits that were struck were bird's eye view maps of the zoning map. And essentially what was argued is that this split zone property reveals itself as an attempt to de facto rezone the parcel in its entirety to a more restrictive classification. The Supreme Court in Saunders versus Clark County Zoning Department held that zoning is in derogation of the common law, deprives owners of the use of their land, and such resolutions are ordinarily construed in favor of the property owner. This matter was construed in favor of the municipality. The issue of the effect, the implication that the enforcement of this order to comply has on the whole parcel, it was construed in favor of the municipality. Against all this evidence, the city points to no evidence other than a bordering zone commercial property was used as retail, that the zoning line let the city have more control over what happens there, but this doesn't establish a substantial relationship to a proper public purpose. I see that I'm almost out of time for my 10 minutes. If the panel has any questions for me, I'm happy to entertain them. But
were all of the tire sales on the U3 section of the building?
they were on both sections of the building.
So
they-
tires through U3 and U3?
Correct. It's, from the outside, it's 4 bays, but there's an office, and they're all connected. It's one structure. And so ultimately, they would be asked to use a third or a fourth of the building, just like they're being asked to use half of the piece of property.
Were you saying that there was 4 bays, so were they also installing tires on the vehicles? It wasn't just a matter of selling tires out the door, retail?
Well, and this is sort of the arbitrariness or ambiguity that gets involved here, because where are sales occurring? Well, the office is in the commercial side of the property. Tires are being stored in 3 of the bays on the eastern side, but they're being stored. I mean, where are sales occurring? It's nearly impossible to create an operation that they have here to be able to only engage in sales on the western portion.
But you're saying that they do tire installations on the premise,
That is true.
in the bays?
Yes,
Okay.
tire retreading, install right there, they'll assist the customers.
Counsel, does the fact that your client apparently, I'm going by briefs, not record, apparently did not request conditional zoning change, does that factor come into play for our analysis? I know the board made a point of saying it, but does it come into play at all for our analysis?
I don't believe it does, because sticking with the standard of review, and I should add a note that across the street, that there is a pending conditional use zoning application before the common police court. So that issue is being addressed in a separate matter. But the record in this case, all that it reveals is that the city could produce nothing that showed that there was a relationship to the zoning scheme that split it directly in half. And everything that was there in the record establishes that it's improper. And it's for that reason that we'd ask the court to reverse the trial court with instructions that the less restrictive U4 commercial classification applies to the whole parcel. Because again, enforcing that order to comply unconstitutionally rezones the entire parcel to a more restrictive use. Thank you.
Good morning, Your Honors. Brian Grumman for the City of Akron. There are 2 assignments of error in this case. The first is whether the trial court correctly affirmed the decision of the Board of Zoning Appeals for the City of Akron in the administrative appeal that was made by Abdelqader Holdings. Something that might be helpful is to understand how this got before the board. When you look at the record, you see that basically Abdelqader Holdings received a notice of violation, that they were in violation of our zoning code. They appealed that decision to the board, and then the board determined whether or not the notice of violation was proper under the circumstances. In this case, the board said that the use of the property constituted a violation of the Akron zoning code. It was then appealed to the common police court, and that's where they raised for the first time the idea that this is unconstitutional as applied to them. And one of the arguments, that gets to the second assumption of error, which we are taking the position that we need to bring this issue up before the Board of Zoning Appeals, at least in the first instance. Now, council has said that they did do that, but if you look at the example that they raised, they don't mention the Constitution at all. What they just say is that this is like, that's arbitrary as applied to them, and it's a very, to the extent that that could constitute raising a constitutional issue, it's incredibly thin under the circumstances of what's going on before the board. But the reason why these should be raised before the board is that there's two reasons really. One, the court should not issue constitutional decisions if there's other ways, other outcomes that would like make it a moot point. And by requiring people to actually put forth all their evidence before the Board of Zoning Appeals, there might be something in there that makes the Board of Zoning Appeals or any other administrative body decide, oh, we're not going to, like, we agree this isn't a violation of the zoning code. We agree this is not a, you're entitled to conditional use. There's reasons why to require this evidence to go before them, so that it can then be, the entire record could be considered by the board, and then when it gets, if there's an appeal, it can be decided whether or not it actually is necessary to reach the constitutionality issue. But another reason why this issue should be raised is when you look at the scheme for the administrative appeals. You say you can challenge the basis of the board's decision on the basis of constitutionality. However, it is also very explicit about the fact that you need to consider only the record that was presented to the board unless certain exceptions are met. None of those exceptions are, you're now raising an as-applied challenge. When you read it in context, clearly you can challenge the constitutionality of the board's decision, but you also don't get to supplement the record with additional information beyond what the board decided. There are cases out there, and the appellant cites them, that have said that you don't need to raise as-applied challenges before the administrative body. We cite to the case of Reading, which is decided by the Supreme Court, subsequent to the cases the Supreme Court decided saying they did not need to raise the issue, and they said you should bring this issue before the administrative body before, in order for the body to make a decision. And we believe that that case implicitly overruled the previous cases. And in light of how consistent this is with the fact that the way the Ohio Revised Code is set up, it would make sense that the reading should be applied in this case, and they should be found they actually waived their as-applied challenge. Getting to the more of the issues in this matter, again, the issue before the board was whether or not what was going on at the property violated the zoning code. There's an argument, the primary argument that's being made is that the Akron zoning code is ambiguous. But they don't talk about any section of the zoning code. They don't say what about the zoning code is ambiguous. They don't say that the map is ambiguous. The map shows what the map shows. They just, well, it's ambiguous what we're allowed to do on the property. But again, if you're going to make this argument, you really do need to go to the Akron zoning code, see what it says, and then make an argument about why, based on what it says, we didn't know what we were permitted to do on our property. They don't do that, and because they haven't developed that argument, that issue should be waived, considered forfeited on appeal here. However, if you do look at the zoning code, it's very clear. What is permitted is defined by the zoning map. It is not defined by the parcel itself. And in this case, the line on the zoning map is actually in the parcel. It goes right through it does go through the parcel. A small portion of the building. I don't want to say whether or not it's a third of the building or not. It doesn't appear to be a third to me, but that could be the case. And the facts that are before the board were there are tire sales occurring in the section of the property that is zoned retail. Selling tires is not a permitted use zoned retail. In the retail.
So
Also,
they have to file a petition for conditional use in that case, or?
that would be, they would have, if they wanted to conduct the property, the sales in that area, a conditional use could permit that, but obviously that would still be that would be evaluated on the facts facts presented to the city council in that case, which is divided, determine the conditional uses for the city of Akron. And with that, and so I don't want to say that if you file the conditional use, yes, you'd be able to do it, it's just more, you could, the question for the board was not whether or not you should be permitted to, it's whether you are. And the answer was no, you're not under the zoning code. And this argument about where the tire sales are occurring, again, that's, I don't believe that's been raised before right now, but regardless, that's, you have to again look at the code, how is it worded, how is it defined? None of that analysis has been done, none of that has. So whether tire sales includes only the office where I'm selling it from, not the place where I'm storing the tires, whether it includes storage. I believe storage is actually not a permitted use in a retail section of the zoning code. So even if it was just storing the tires, I believe that would still be a violation. So all these arguments that are being made are really not about the zoning code, it's just whether they think the zoning map was properly, was drawn in the way that they would like it to be drawn. But if you review the entire record in this case, what you're going to see is that there's no evidence that this property, that this zoning map was changed at any point relevant to this case. The zoning code indicates that the last time the map was changed was 1979. So to the extent that the Abdelqader Holdings has rented the property, it appears that they rented it knowing what the zoning code was, conducted illegal use on that property, and now want to say that it's somehow unfair that they're being told they can't do that. That's not, it goes against the very idea. You don't get to basically violate the law and then complain about the fairness when it's enforced against you.
Well, maybe they looked at the fiscal officer map.
I don't, Your Honor, I know they've raised that issue, but and despite what people may think, the city of Akron is not the county. And it's one of those issues where the way the county wants to define that property is not indicative of what our zoning map shows. And our zoning map shows that the majority of the property is retail. And so any way you want to slice this, the majority of the property is retail, the majority of the building is retail, and the majority of where all the tire sales are being done is retail. And you cannot do tire sales in the retail area. So as far as the issue about the administrative appeal from the Board of Zoning Appeals, whether the notice of violation was proper, that the trial court correctly determined that should be affirmed. And we would ask the court to overrule that, the first assignment of error on that issue. I apologize, I don't see what my time is left, but
I do not have 15 minutes left.
I'm guessing not.
Yeah, you know what? Well, anyhow, go ahead. We'll go
the-
with
the,
the whole time.
The other issue I wanted to talk about a little bit was the idea of the constitutionality. One of the issues that's kind of being raised here is the idea that the as-applied challenge should be able to be raised. And as I said, I understand there's case law out there that says you can raise it for the first time. I understand that, but we're saying that there's more recent case law that indicate you can't. And we believe that that decision is more consistent with both the Ohio Revised Code for the Administrative Appeals and is more consistent with the rules of how the court should be looking for constitutionality and applying those. Furthermore, if we actually started looking at the issues that are being raised, the area surrounding this property is zoned retail. To the east is zoned retail, and then it's being used for retail to the west, and then to the north, it's zoned residential. Their argument is basically, well, we think that our property should be commercial, but as other courts have pointed out, commercial districts have to start and end somewhere. You have to make a decision, and in this case, the land use map creates a buffer zone of retail from the commercial use districts between commercial use and the residential. That is not arbitrary. There's a reason to do that, which is you try to make sure that the residential houses don't have commercial uses happening right next to them. And as you go, and again, those properties.
The residential properties, though, in this case, did abut U4 commercial zones,
Excuse me?
right?
Uh,
Did you not?
His question was the residential property did abut the U4 zones.
I don't believe they did, but
Walked into the north.
the R3 abuts the residential. The U3 abuts the residential. I do not believe the commercial zones abut the residential. But
Okay. It is what it is, so.
Yeah.
Right, and I apologize, Your Honor, but that's, if you're looking at the map right there, I have not looked at that, recently. But again, these are closer to the more of the residential homes at the very least than the ones further to the west. Also then across the street, I believe it's zoned, commercial as well, but again, this looks like it's been zoned this way for at least 40 years. And if that's the case, it's, to basically move onto the property and try to use it for an improper use does not make it unconstitutional. Like it's not, you don't have a vested interest. In the case that they cite on the Hectal case, involved zoning being changed on them. But in order for zoning to have been changed here, you'd have to actually make an argument that it was a permitted use prior to the decision of the BZA. And to do that, you'd have to actually look at the zoning code, what the zoning code permitted, and how it defined what the boundaries were for where the uses were. And they don't do that. They don't conduct that analysis. And they can't then turn around and say, well, it's unfair because just because we want to use it for something. That's not the standard. The standard is whether or not the decision to draw the line where it does not have any reasonable connection to police powers, to health, safety, and welfare. And in this case, there's no evidence that it doesn't. There's no evidence about that. And they didn't raise this before the board, and as we point out, when this was raised for the first time on appeal, we went and we actually got the certified document from the clerk account, from the fiscal office. This property was merged with another property. The zoning line was basically created by the property owner, the split. And this goes to the bigger issue here is that the idea that we can't split a property kind of makes it so that people can really end run the zoning code as a general rule. And we made the analogy of like a giant piece of property, if you merge, that's all residential, you merge it with a single acre that's industrial, then you can do industrial across the entire property. Obviously that's like hyperbole, but the point, it becomes a matter of where do you draw that line. If you can say you can never split a parcel, it seems that it's very easy to see how you can just consistently add pieces to the property until you get to do the use that you want based on pieces and part of the zoning map. The zoning map never mentioned parcels. The zoning code doesn't mention parcels. It was based around where it is in the city. And in this case, where it was in the city was on the former property line, which has then been merged into this building. And under those circumstances, I don't believe that there's actually a basis to allege that it's unconstitutional. And I'll respect for the fact that I don't know how much time it was. I would ask you to affirm. Thank you.
Thank you.
Yes, I just want to briefly address a few points that were made by counsel. To the extent that any argument about the history of this parcel and at what point whether or not it was a single parcel and when it became single, it's not even part of the record. But in any event, to suggest that there is this slippery slope, unimpeded opportunity for property owners to, around the city, merge and consolidate their parcels in order to avoid zoning restriction issues is far-fetched in as much as step one of any of those types of scenarios would involve approval by the zoning department itself. And so it's not unimpeded, and the very party that would complain about such an action is the party that authorizes or doesn't authorize that type of consolidation. With regards to the constitutionality, again, I think some of the oral argument sort of reveals what's in the briefs, and that is the northern bordering properties being used as residential, being zoned as residential, and the argument that this retail section of this one parcel is a buffer zone doesn't hold water because all of those properties are bordered to the north by residential, every one of them, including the commercial zone portion of the parcel. And so the cold record reflects this type of argument, and it reveals itself as a method to rezone, to de facto rezone the whole parcel. I'll direct the court's attention on the transcript for that very reason to page 8. The Department of Planning and Urban Development is attempting, through their order to comply, to de facto rezone my client's property from a U4 commercial to the U3 retail business on the argument that the other properties surrounding my client's property are also retail use. With regards to the constitutionality, there's no magical word constitutionality that needs to be said. I can find no case law that says that there has to be that word usage in order to appropriately raise constitutionality before the administrative agency. What was specifically argued, page 19 of the transcript, my client is utilizing the property in accordance with the least restrictive zoning designation. A more restrictive zoning designation applied to the property, which would be a U3, would be an undue burden on the property and unnecessarily a taking of the property. The transcript is riddled with argument that Abdelqader is entitled to use the least restrictive classification when enforcing the more restrictive classification directly affects it. The policy behind making these arguments at the administrative level so that the record is clear, so that it can be developed. It is developed. Arguments were actually made. They weren't reserved, like the case in Reading, the Supreme Court case that the BZA uses in support.
Counsel, I gave you a minute over on rebuttal because I think I actually ended up giving Mr. Bremer a minute over, so.
And thank you for your time.
All right, thank you both for your arguments. The court will take the matter under advisement and issue its written decision, which will be mailed to both sides as well as posted on our website